So for someone who is in the audience and they're not familiar with this, let me start with you, Peter. What is rent to own?
Good afternoon, everyone. Yes, rent to own, or if we may, the tenant purchase arrangement, is a plan or an arrangement where, as you occupy the house, you have an arrangement where you actually buy the house that you are occupying over a period of time. So you have a contract with obviously either the developer or the person who is selling the house to you, but rather than pay outrightly at the beginning, the arrangement is such that you pay a deposit towards the purchase. You agree on a purchase price so that you lock it, pay a deposit, agree on a time period. Typically, it actually varies from 5 years to some going up to 18 years, where you can be paying over time. You building interest rate over that period. I have seen interest rates ranging from 8 to 13 or 14% over the period of time, and the ownership will be transferred to you once you pay the full amount. Again, you can also have an arrangement like the rent to own, where you come in, you lock in, you pay a lock-in, you agree on the purchase price, you pay a lock-in fee, and then you have an option. That option will be exercisable after a number of years, so you're not paying the installments at that point. You are paying rent, but you have an option which you can exercise as a tenant after some time. Once you exercise the option, then you are then able to buy, because at that time you have built your credit and you're able to get financing for a mortgage.
Peter, let me take us slowly. So let's break down a few of those issues you have mentioned. First, and let me bring in Washington at this point, you have spoken about a lock-in, which sounds pretty much like a deposit. So the question, because I was moderating a conversation on rent to own just a month ago, the question which typically emerges is, how do we determine this lock-in amount? What percentage of the agreed value of this unit should it be, Washington?
Thank you. Maybe some of the instruments that my brother is talking about may be foreign to what is actually happening in this country. The issue is the rent to own or tenant purchase arrangement was introduced to this country by National Housing Corporation. Whether you're buying a serviced plot over a period of time, or you are buying a house over a period of time. And remember, high-rise buildings ownership came in 1989. So before, it was either a maisonette or a bungalow. A property or an estate was developed, price given, and you were asked to pay 10% deposit. Once you have paid the 10% deposit, you move into your house and you pay mortgage normally. Now, at an agreed interest rate, monthly installment. Every payment that you make per month goes towards paying the principal amount, the interest that has been charged on that property, and service charge. So that one would not say it is a locked-in. You just pay a deposit of 10%, and it is known that is part of the purchase price. Thank you.
Washington, let me stay with you. I can imagine in the audience you might be wondering, so what's really different between this and the mortgage?
The difference here is that as for National Housing Corporation, the interest rate does not change, but the principal amount reduces with time. All right? So it is like you fix the interest rate, you fix the period, if it is 10, 15 years, 5, or 25 years as we are doing for social housing. And therefore, the difference is that interest does not change. It remains the same.
Okay. So it's a focus there on the pricing of the facility. Let me come to Peter. Any comments on that, by the way?
Yes, I'd like to comment on that. Let me give you a typical example. And my colleague is right that National Housing sort of started off this process going back to the 60s. And some of the residential estates we have that are based on tenant purchase actually were premised mainly from NHC. And you find like a typical example. Let me give Kimathi Estate. Kimathi Estate is one of the residential premises where you have a tenant purchase scheme. What do you have? What you have is a tenant purchase agreement. That tenant purchase agreement sets the price, sets the interest rate as he has indicated, which is a fixed amount, but it's almost like purchase by installment, because then once you pay the deposit, then you are going to pay over 180. I've seen some of the contracts, 180 monthly installments, or others 240. So that translates to a monthly payment over 15 years, where you are paying based on 8%. But the interesting thing here is that although we call them tenant purchase, you are really is a buyer in possession, is a purchaser in possession. That has some nuances as we'll discuss, yes.
So the question always emerges when you talk about the rent-to-own arrangement. What's the underlying regulatory and legal framework that guides TPS in this market? Or is it a preserve of government and NHC? Washington, please.
Not really. Initially it was NHC that provided this facility. But of late, if you've seen the past 5 years, a number of developers have come on board. And even banks are now realizing that tenant purchase is key towards home ownership. The main fundamental issue is that it gives you time to save. Because when we ask you to pay 20% and it is 800,000, you may not have that in your bank account. What we have done in the past is that whenever a project starts, whenever project construction starts, we allow you to pay your deposit during that time of construction. Maybe halfway through, we are able now to allocate houses for those who have met the threshold. So to that extent, that gives Kenyans a time within which they can pay the deposit, because deposit, just like these other expenses which were being discussed earlier in the day, in the morning, are fairly expensive. 200, 400, 300,000 is quite some money. So it gives you time to up the deposit. You pay incremental deposit up to a particular time when when allocation now is done.
Okay, let me come to Peter, and maybe now tweaking the question a bit, and why I was asking that question of the legal and regulatory environment is the consumer protection aspect always comes out when we have this conversation. So maybe I inked a deal with a developer X, and they don't meet their end of the bargain when it comes to developing the unit. How does that work?
You actually find that that's one area where we have got a dearth. We have got an absence of a legal and regulatory environment governing this area. This area has grown mainly as contract-driven, where people agree based on the tenant purchase agreement. If you look at it, the NHC, if you go through the Act itself and the regulation, you find very little in terms of guidelines as to how the tenant purchase process will actually operate. Because at the beginning, it was tailor-made for civil servants. So you find way back in the early years, we had regulations that were guided towards civil servants, because maybe creditworthiness was easier with them. And the reference point you find was a guide only limited to an institution that was going to manage the fund under the Act that will regulate how the ownership will go. But when you come to the actual transaction, it was relying on the actual contract itself. So you find, specifically to that issue of the consumer protection, if you go to UK, you go to USA, you go to South Africa, they have got under their Consumer Act specific legislation that links of the tenant purchase ownership with consumer protection. Some of the issues that we just saw here about the quality of so many other things. In Kenya, our Consumer Protection Act actually outs immovable property. It actually does not cover mortgages. It is expressly excluded. So you find that in any such development, you now have to forage through a number of laws to try and align yourself with some of the protection that you are concerned with as a person if you missed it at the contract stage. And that has been one of the key, let's say, areas where, although the private sector has moved and is beginning to embrace it, but the contractual underpinnings is what regulates it more than the regulatory environment.
Let me just add on to what my brother has said, Peter. The realization that we have conmen in this country positioning themselves as developers calls for a regulatory framework. A number of developers have come on board, and these days, everybody is a developer. The lawyer realizes that there is a gap, and he works with the banks, works with a number of institutions, and they call themselves developers. And at the end, some people come from out there. I remember there was a very major case sometime on Mombasa Road, where he takes a lot of deposits from vulnerable Kenyans. And after a few years, there is no development, and this person disappears. How do you get back your money? And Kenyans trusted private developers. That's why perhaps they may need to continue trusting National Housing Corporation. Because when you look at what has gone on as we speak, and I'm happy that the chairman in Parliament of the housing sector is here. One of the issues that we had given in the housing bill, which has not been passed to date, is regulation of housing development. And it basically to ensure that the safety of Kenyans' money is put in law. That once that bill is passed, then we will have a regulatory framework. It is not yet out, but it will show you how we intended to manage the sector with a view to getting away these fraudulent people coming to fleece Kenyans. There is a real need, more so working with the private developers. Their money is safe with National Housing Corporation. Thank you.
And that's that's precisely why I asked that question on regulation. And I want to invite the floor. As I continue asking questions, please just shoot up your hand. If you have a question, I'm happy to take it as we continue flowing with this conversation. So, gentlemen, I've been asked this question before on matters regarding the rent to own. When I get into such an arrangement, how should my monthly installment play vis-a-vis the average rent being paid within the specific area for that kind of a unit? Should it be above because I have baked in interest, etc.? Should it be below because this should be a cost-effective means of affording a house in the long haul? Peter.
Yeah, before I do that, in defense of the lawyers in the forum, the example just given about lawyers, I must protest that Housing Finance in 2 occasions have relied on lawyers to try and streamline some of the projects when they have been taken to court and they have been saved by lawyers. But more to the point that you mentioned, the issue of the payment that you do, the logic of getting into the tenant purchase is that the rent that you subsequently pay should come at a discount because it is you have locked in over a period of time. Remember, it's based on a negotiated purchase price. That purchase price, because it's paid over a duration, you'll find that sometimes it's slightly above the market. If you had to look at it on value, that's in theory. And so the discounted price is supposed to be, the installments are supposed to be marginally lower than what the prevailing rentals are. But because it's of what I mentioned about the unregulated nature of this area, whereas in other jurisdictions you'll find guidance as to how much the tenant purchase prices should be. In Kenya, we don't have that. So it very much now depends on the developer and what price ranges they're able to agree.
Washington, any input on that?
Normally it is slightly higher, just slightly higher than the market because there is the element of interest rate which is also being payable per month. So if you go to our Langata estate, the market rent is about 40, but what they are paying is about 55. So as an owner, you are basically buying your house, then you are paying slightly more for a period of 10 to 15 years.
But Washington, 40 vis-a-vis 55 is not marginally high.
If you consider, if you are just paying rent and nobody is appreciating, never at any one time, the landlord will never tell you that you have paid 40,000 for a very long time. For the next 6 months, now don't pay me anything. Now, if you know that you are owning, you are actually buying your house, it is much, much better to pay that extra 10, 15,000 to own the house than pay 40,000 and never own a house.
Fair response. Any questions so far as I continue? Yes, let me take from Sita and Nyale, and then we'll continue.
Thank you so much. I feel TPS is really important because of the challenges we've been talking about mortgage registration. And my understanding is that TPS is no different from a mortgage. The numbers are the same. We say this is a 5 million house, this is your 1 million deposit. We actually do the same Excel payment, and we call it a TPS because we can't charge the property, we don't want to do the foreclosure, etc. So the only institutions who've been able to do TPS are institutions with concessional funding, like NSSF, NHC, etc. And that's the thing, like how do we get it more in the market? Because who else has concessional funding? Is that something KMRC can try? And can we also share the contracts and the financial models so everyone's not trying to create it? We have millions of units to create. So yeah, that's my big
question. How do we scale this? Nyale, your question?
Thank you so much for that great discussion. I'm just wondering, in the time when they have entered that contract and the person renting has put the deposit and the contract is going on, who is in charge of maintaining that unit? And maybe not the minor repairs like paint and everything. Suppose there is a major repair of the unit that needs to be done. Is it the tenant who will later become the owner of the house, or is it the developer?
How do we go about this, gentlemen?
Let me set it off. One is to campaign amongst all of you who are here present that my brother Johnson Ole Tita must make National Housing Corporation a shareholder in KMRC.
Joe, are you
because of that question that has been asked. How do we scale it up? KMRC is dealing with the demand side. That demand side, the banks are still restrictive. They have not given any concession. And the banks are giving loans at a lower interest rate, yes, but they will still evaluate your credit worthiness, just like in the normal manner. And you'll find that a number of Kenyans cannot even access this money that has been financed by the Kenya government, World Bank, and the rest of DFIs. To that extent, the supply side has not been supported. And that is where National Housing Corporation is coming in. And that's what we have told KMRC, that we need to look at solutions on the supply side to take care of, to scale up now the TPS arrangement. On the second question, by law, the developer has a responsibility of maintaining the common property all the common areas, external, that is the responsibility of the developer in terms of repairs and maintenance. All major works, if they are capital in nature, that we are now we are trying to get away of financing capital works, because in the course of the life of the TPS, there may be a need for major works which were not envisaged. But the internal repairs is the responsibility of the purchaser. And internal means if it is blocks of apartment up to your door when you get onto the corridor. Thank you very much.
Thank you. Let me bring in Peter here.
Yes, if I may actually go back to Sita's question in terms of the structure of tenant purchase. Remember, this is an agreement. It's an agreement to buy a house, but stretched over time. Slightly different than a mortgage, because by the time we're talking of a mortgage, ownership has shifted. In the case of a tenant purchase, that ownership will not accrue until much later after you have paid everything. That is when the title will be transferred. And some of the interventions we will be looking for, maybe later in the discussion, is the ramification of that in terms of legalities, in terms of cost, in terms of taxes that you pay, of stamp duties and all that. But more importantly, and maybe for purposes of KMRC, remember KMRC refinances mortgages. Is already, there's a primary mortgage lender, and KMRC comes in to refinance an already existing mortgage. And looking at the regulations of KMRC, we are talking of fully secured mortgages. So that brings in the fundamental difference between this aspect of the tenant purchase and mortgages. So until such time, and this goes to scalability, until such time that we have got regulatory changes that will enable proper interface with the law to make it a bankable product in a manner that is scalable in the sense of financiers, then we can talk of receivables. Receivables being harnessed in a way that will be of interest to a financier like KMRC. Yeah.
Thank you, Peter. Two things. I'm told the next presenter is waiting, so we'll expedite this process. Let's take that question and that lady, and then we come back here. Very briefly.
Fine. Thank you so much. Mine is not more of a question, but because we have the Housing Committee Chair, MP Mr. Ngeno, that I just left campus the other 3 years ago, and I think I discussed this last time here, and I wish that I reinstate it based on a comment from Mr. Washington, which he has touched on, that we have fake developers around. We have experience around institutions in Kenya, especially maybe I'll say an institution where I learned at in Eldred, whereby we have developers who bring up houses just to exploit parents. Most of us here are parents, Indio. Yeah, and then you find that they are charging students higher rates of rent. So if you're talking about affordability, I don't know how KMRC can come in to ensure that these developers also look at the rents that they are putting for, especially our areas around institutions, and I think Mheshimiwa Ngeno is taking note of that.
Thank you, sir.
Yeah, finally, yeah, I also talked about, I think I'm out of time.
Yes, you
are.
Please pass the mic to the lady here.
Good afternoon, my name is McKenna. My question is directed to Peter with regards to the structure of this tenant purchase contract. How do you handle a situation where the tenant, during the course of this arrangement, for one reason or another, decides to relocate to a different house or a different unit and would wish to continue with this arrangement where they eventually become the owner? Do you interpret the word tenant in your contracts strictly to mean the tenant and that they must be in possession, or do you allow your tenants to assign their units to other people in the event they upgrade?
Thank you very much. And that, so we have two questions. We have one question to the Honorable MP. We have that one going to Peter. And that question for Peter, let's start with you maybe. Is there an exit clause in this sort of arrangements?
I have actually looked at a number of TPS agreements, tenant purchase agreements, and there is an exit provision. And what I've seen, let me again give an example of what I've seen. There is a lock-in period where you are not supposed to leave the premises unless due to some specified reasons which are set out in the agreement. Then in the event that after that, after that period of time, your right to either assign your interest to a third party is provided for, and the mechanism for how you can assign that interest is provided for. Or in the event that you want to exit, as in sell, is also provided for. And also in the event of a breach, because there could be a situation where you got in and then you are not able to complete, again, there's a provision for that. All that is contractual, and it depends on the developer who is actually you are contracting with, because it's not regulated like in UK where there are certain provisions, so it is how you negotiate. And what the exit provisions are is that if you have paid, let's say for a considerable period of time, then you are not able to proceed, and the developer can step in because you are in breach after giving you notice. In the subsequent resale, if there is a markup after recouping the balance of your amount and their cost, that extra is supposed to come to you. That is a contract that I've seen. In case you actually want to exit and want to assign to somebody else, again, there are assignability provision where you can transfer your interest to a new party who, with the consent of the developer, and then you get your markup due to the negotiations that you have had.
Gentlemen, I'm told Rory, our next presenter, is waiting on set. Let me just invite you, starting with Washington, give your closing remarks very briefly.
We want to support KMRC because they are doing a good job. We must also know that 40% of Kenyans and the world population rent houses. And the issue of renting houses, or houses for rent, must take center stage, just like we are trying to discuss home ownership. 40%, nobody in these urban areas, you will never say that everybody must own a house. It has never worked anywhere else. It almost worked in Libya, but never anywhere else. So we must also give focus to renting of houses or houses. That's why the government of Mzungu built houses here for rent. The second one is some legal issues. If we are to scale up home ownership, particularly apartment buildings, Sectional Properties Act, even though it was amended a year and a half ago, it still has certain areas that still need to be amended to allow for faster ownership of houses. I think we are good to go. We are ready to give you the affordable housing. And that affordable housing must be looked at from the top to bottom. We are not just looking at the low income. Even the middle income, they also have challenges, even the upper category.